Okay, good evening, everyone, or good afternoon. Thank you for joining us. I'll just give it a few moments before Zoom starts and does its thing. Let me introduce my colleague, Amritpal, relatively new member of Chambers. I say he's probably been in here 18 months or so. Something like that. And I'm Michael Salter. Today, we're going to be talking about injury to feelings in the Employment Tribunal. But before we get on to that, just a couple of housekeeping notes. This is the sixth, I think, session in our latest employment law series. So if you want to go and find them, they can be found on our website or our YouTube channel. You should have received a handout for today's talk, and that should have come through this morning. If you haven't, please email events@42br.com, and that will be sent through to you. There will be time, hopefully, at the end of the session for any question and answers, and any questions we don't get around to or aren't able to fit into the time, we'll respond by email. If you're watching this via a recording, again, please email events@42br.com, and we will answer any questions that we receive. Now, this session, as I say, will be focusing on injury to feelings, and I think we're all adults here. I think we should address the elephant in the room, that injury to feelings is frequently underdeveloped in witness statements. It tends to be unexplained or underexplained in witness evidence, and it's very often underjustified in any schedules of loss. And it's always dangerous to take quotes out of the context in which they were given. But Mrs. Justice Yip, in the Edward Wright and Satellite Information Systems, a High Court case from a couple of years ago, described a schedule of loss, as a document that draws together the presentation of a claim, and it ought to be presented in an accessible and easy to follow format. This means that it should not simply be a series of calculations. It needs to be supported by sufficient narrative to explain the case being presented by the claimant. And I don't think that could be further from the truth in employment tribunal schedules of loss, when injury to feelings you just have this bald figure of £12,000. Perhaps you might get £12,000 middle band of vento, but very, very rarely do you get any real narrative or any scaffolding or any indication of the evidential foundation. And this is a real problem. I think it's a real missed opportunity for claimants. Firstly, they run the obvious risk of being undercompensated or being disbelieved because there's nothing to support what they say. But equally, it robs them of a real opportunity to set the tone or gain the momentum and the initiative on settlement negotiations. There is a huge period of time between the entry of an ET3 and a case management hearing. You know that one of the orders any tribunal judge is going to give is for a schedule of loss. Why not get ahead of the curve? Why not, before the case management hearing, put a schedule of loss in by the claimant with an injury to feelings award, and then bullet points as to why you say it is the middle band of vento or upper band of vento or lower band, and justify that. That makes it very hard for the respondent to say to their clients, we don't agree with this calculation. It already puts a bit of pressure on the respondents, if they are looking to settle, to come up to a figure around your or the claimant's indicated schedule of loss, if there is justification for it. If there isn't, if it's just the usual bald figure, it's very easy for a respondent to go back to their client and say, we don't agree, the case is worth that money. The more information you give, even bullet points, I think is a real opportunity for claimants to see some initiative. A bald £12,000 is also harmful for the respondents. You can almost see there's a concession by silence argument. It's hard to engage with it because we don't know where to start. Well, that's really not very appealing for a tribunal to hear that from the respondents. Equally, it might result in over-defensive offers where the respondent simply caves in as a midpoint figure just to try and limit any potential exposure that they may have ultimately in the case. It also creates difficulties at a hearing. Tribunals, I think, may find it easier to accept a figure, however high, if there's no coherent counterproposal. Without a respondent's analysis of, and these are the points that Amritpal and I will come on to in a moment, without an analysis of a respondent's assessment of the seriousness, the duration of the impact, without a properly drafted counterput schedule, there's a real risk that a tribunal may just simply default into what it feels is proportionate and not really dig around within the weeds of what the claim and what the valuation of that claim is. So there's real challenges for the respondent, challenges for the claimants, and if an advocate's job is to make the judge's role and determination easier without a decent schedule of loss, without a decent assessment of injury to feelings, that job gets very, very difficult. Now, if you are interested in previous discussions on schedules of loss, in previous series, a colleague of ours, Max Gordon, did a webinar on schedules of loss, and I think as part of this season, the two Alexes did a very, very entertaining webinar on schedules of loss. So we won't hopefully trespass too far into what they've discussed, but hopefully a useful set of 3 webinars to look at and to hopefully gain some assistance on. Now, so the aim of this session is quite simple. It's to hopefully plug that gap between the bald assertion of a value and an actual well-pleaded, well-set-out schedule and counter-schedule of loss. We'll look at how injury to feelings should be assessed, and hopefully some good and bad practice points and what they look like from both sides of the equation. Now, it's particularly important because we all know injury to feelings is available for Equality Act claims. It's also available for other claims that are based on a status, and relatively recently, Her Honour Judge Eadie, in the case of Roe and London Underground, gave a good and careful analysis of where injury to feelings awards can be granted. And basically, if it's a claim arising out of the status of an employee, then, for instance, trade union, more likely to be able to claim injury to feelings there. If it's a claim that just arises from a breach of a statutory right, for example, health and safety, you're unlikely to get an injury to feelings award. Means claims under Trade Union Labour Relations Consolidation Act, yes. Protect interest disclosure and detriment claims, yes. And also, obviously, the Equality Act, all based on status. That said, there are various sets of regulations that expressly exclude injury to feelings awards, fixed-term employees, part-time workers and agency workers regulations, to name but 3 of them. So the key for, I think, this entire talk and the foundations of injury to feelings is that it's akin to almost general damages, if we can cast our minds back to our days in law school dealing with those. And the tribunal is tasked with a very odd and very difficult mission. It is asked to award for a non-pecuniary loss, which is based on a subjective impact and is going to be assessed by perhaps not the strongest of evidence, and assess that in a financial value. Whilst we see that in general damages in claims for like nuisance, defamation, unlawful eviction and harassment, to name some, they all focus on how an unlawful act injured someone and their life experience. Now, in employment tribunals, that focus is sharpened by some cases that Amrit is going to be talking about in very few moments, of Cannock and Johnson. And those frame injury to feelings as a tortious measure of damages rather than contractual. So I'm going to hand you over to Amritpal, who's going to just take us through the basic legal principles and some recent case law.
Thank you, Michael. Just a quick run of the basic legal principles with respect to injury to feelings. Really, the tone was set in Prison Services versus Johnson. You will see in the workbook that we provided, there are we put in the sideline some of the cases that are certainly worth considering with respect to injury to feelings. The key principles established were that injury to feelings are about compensation. They're not about punishment to the respondent. Those sorts of damages come under a very separate heading. Injury to feelings are very much about putting the claimant in a position but for the act of discrimination. With regards to punishment, it's often something that gets conflated. And also in the case of Chorus Hotels and Woodward, which is also set out in the workbook, it was also again emphasised that it is not about punishment. And it's important not to conflate the award of injury to feelings with the indignation and outrage an individual may have towards their employer. That's particularly important because that's not the idea of injury to feelings. It's really about how the act itself has caused distress and upset to the claimant. It's important to make sure that awards are not too low or even excessively high. There has to be an element of public respect for injury to feelings. Discrimination, in the case, it was said discrimination has been pretty much looked down on in society, so it's important that the award has an element of respect and credibility to it. There was also a point towards having a general similarity to the awards in personal injury cases. In the case of Ministry of Justice and Canup, again, as Michael said, the injury to feelings are compensatory, not punitive. It's also important to remember that they're not automatic. So if there is a finding of unlawful discrimination, it doesn't mean the claimant will get injury to feelings. It still has to be something the claimant has to prove that they have an entitlement to be awarded. Vento, everybody will be aware of Vento versus Chief Constable of West Yorkshire Police. This sets out really the type of feelings we're talking about. So subjective feelings of upset, frustration, worry, anxiety, mental distress, fear, grief, anguish, humiliation, unhappiness, stress, and so on. Different bands were set out. So we have the lower band, which currently is between 1,200 and 12,100. And then there is a middle band, and then there's an upper band. Upper band is reserved for most serious cases. Is also most exceptional cases are capable of exceeding 60,000. Since the case of D'Souza versus Vinci Construction, 2017, Vento bands are annually updated. So what is relevant is when the claim is presented, and there's presidential guidance that comes out every year, and it's important to check when arguing for injury to feelings, at what point the claim was presented and what was the presidential guidance alive at the time. An important case quite recently was Eddie Stobart Limited versus Miss Kathleen Graham, 2025. In this case, there is a discussion about the manner of discrimination and how that can itself assist with drawing inferences as a secondary fact in a very narrow range of cases. And it's something we'll touch upon later when we come to discussing about how what the tribunal wants from the claimant. Helpful summaries are set out in also a case called Sadia Shakil versus Samsung Limited, 2024. This sets out the principles for injury to feelings and also the aspects of a case where the tribunal's approach can go wrong. This takes us to our first topic, which is what does the tribunal want to see from the claimant? It's important to note that it is subjective evidence, and that's particularly key. And as Michael said earlier, it's it's a missed opportunity, because if there is nothing but a one line, or if that in a witness statement and very little in a schedule of loss, it does make the tribunal's task very difficult. It's certainly a lot more open to the respondent to challenge the claimant with respect to what their damages or injuries feelings are, but also it puts the claimant on the back foot, and awards are based on the claimant's description and the claimant's evidence of injuries feelings, and it's important that these are adequately addressed in witness evidence. What the tribunal really wants to hear about is the description of the injury. It may seem that this is relatively straightforward, but the tribunal wants to hear about the claimant's account in their own words of how the unlawful treatment made them feel. It's important that they set this out as fully as possible, because this is really going to be the building block when it comes to assessing injury to feelings. And it will be this that the respondent counsel will challenge first of all. If this basic information is missing, it's very difficult for the claimant to then proceed forward. There are certain circumstances, for example, overt discrimination, which I'll touch on later, where the act speaks for itself, and it's very obviously going to cause injury to feelings, but that is not the case for everything. So it is important for the claimant to set out precisely how they feel about what has happened to them. The next point is to really explain why. And again, this may seem like a very obvious thing, but often it can be, it's not just the act of discrimination, but it may be the exposure and how long an incident lasted for, whether it was in front of people, whether it was, there was a power dynamic in there. And that will feed into precisely why an individual perhaps is not just upset about something, but there is prolonged distress. This is exceptionally important to deal with because it assists the tribunal determine injury to feelings. How long do those injury to feelings last for? I mean, often in cases there may be an acute stage, there may be a recovery stage, there may be residual effects, and it's important to describe and deal with these as fully as possible. If injury to feelings are continuing, then consider explaining why they're continuing. How long are they likely to last for? And is there a trigger to them? A situation may be, for example, if injuries to feelings affect an individual's future work. And so there must be a reason why that. Is it because it's the same line of work? Is it because their self-esteem was bound up within their occupation? Sometimes there can be an effect on personal life or quality of life, like personal relationships, private activities, hobbies, that sort of thing. So it's important to set those out and explain why and how they are affected. The focus has to be on injury to feelings, not the injury to health or personal injury, albeit there may be some overlap, but it is important. That is where the focus should be. Sometimes there could be pre-existing issues. For example, if an individual suffers with depression. In this situation, it's important that the individual explains, is there any aggravation of it and or any exacerbation? Because that might be something, a point the respondent takes, and therefore it will be something the tribunal explores as well. An important point here relates to aggravated damages, and of course, Michael will touch on this later, but did the respondent do anything to aggravate the injury to feelings? In other words, make it worse. Examples in a case I refer to later, Met Police versus Shaw. Examples are given in there about the employer trivialising the discriminatory act or promoting the discriminator. If there's issues regards to motive or subsequent conduct, these are factors that potentially make the injury to feelings that have already flown from the act of discrimination worse. And if there are these aspects, it's important to set those out. Consider, if you need to, speak to individuals about if they can assist with evidence. It's a point I will return to. Often in cases there are multiple acts of discrimination, so consider speaking to those individual acts if necessary. Bearing in mind, the Employment Tribunal will generally only award for successful acts and make a global award because it's unrealistic to separate them. But if necessary, there may be one particular act you want to focus on, and there's particular reasons for that. It's important to set that out if you think it's relevant. Equally, speak to the relevant protected characteristics if two separate ones are relied on separate acts. And finally, mitigation. Again, Michael's touched on this already, and we'll return to it, but mitigation is exceptionally important. It will be a point the respondent does take, and it will also be a point the tribunal will take. Bearing in mind, awards cannot be too low, they can't be too high. Mitigation is really you would call it like a buffer, where is this the right award? Has the claimant done anything to try and make themselves feel better? Consider including that in your evidence as well. Other evidence you could have to support would be, for example, a work colleague, friend, family member. Bearing in mind, if these individuals do not attend, there's only so much weight the tribunal can put to their evidence. But evidence from individuals can assist with injury to feelings if it is relevant and if their evidence is particularly crucial and important to demonstrate the seriousness of the injury. In some cases, it may be important to have direct evidence on health. For example, if there's a need for a formal medical diagnosis, there may be records of clinical support and counselling. These are helpful if there are issues about proving, showing the seriousness of the injury. As I mentioned earlier, it may be that in some cases the Act speaks for itself. And this is a point at paragraph 44 of the Eddie Stobart very, very recent judgment. The Employment Tribunal explains the manner of discrimination is a tool by which the tribunal can properly draw an inference of secondary fact as to the injury suffered by the claimant when, as often happens in such cases, there is little else to go on. The Employment Tribunal set out those circumstances, and there are very narrow few situations. Say, for example, the manner of discrimination can be a benchmark as to where to start assessing the severity of the injury. And in those situations, secondary inferences can be drawn from the discrimination. For example, if it's overt discrimination, in which case it's perhaps, putting it crudely, obvious that feelings would be injured as a result of it. Or if there's discrimination in front of others, there's a power balance situation, or in certain types of pregnancy discrimination. And it's set out again quite helpfully in the case of Eddie Stobart. Important to mention here that this is not the same as aggravated damages. The manner of discrimination, it works separately for aggravated damages. Drawing inferences relates to more if you are trying to prove simply from the act of discrimination itself. Often, if there isn't anything else to go on, then sometimes contemporaneous evidence can help. Grievance letters, GP notes, occupational health records. These can sometimes show contemporaneous notes and details of how the claimant felt at the time. And so if these are already in the bundle, it can be incredibly helpful. So if that is what the tribunal is expecting from the claimant, in order for the tribunal to decide the damages, what is the tribunal going to expect from the respondent?
Well, what the tribunal will expect from the respondent is a clear and evidence-based challenge to contextualise the award that's being sought. Now, what we've got to be very, very clear on is how the tribunal should go about that assessment. How it should go about the assessment is looking at, obviously, the Vento brackets, but the correct interpretation of the Vento brackets. It's very unfortunate that quite often you have representatives who say, oh, it's a one-off act, it's bottom bracket of Vento, or it's 2 or 3 acts, therefore it's middle bracket of Vento. That's not what Vento says. What Vento says is you've got to look at the impact it has on this claimant, and the brackets are based around a set of example circumstances and situations that may be indicative of where into what bracket they fall. So the number of actions is not sufficient to say it's in the bottom bracket or in the middle bracket. It's that impact on the claimant. And one of the things many claimant witness statements miss out is actually explaining injury to feelings. Firstly, you need to show what the feelings are. And I think there's a real missed opportunity for claimants to put into their witness statement how they were before the discrimination. That sets almost like a medical baseline. Well, if you change GPs' practices, the new GPs always want to get a series of tests done to establish the baseline for their future care review. And the same is true with injury to feelings. I think claimants miss the opportunity of saying, prior to all of this, I loved my job. I was giving voluntary time there. I was mentoring new recruits to the business. I was going to all the staff away days and that sort of thing. That sets the baseline against which you then have to prove the injury. Too often, what you see is just a statement that says, and may go into some detail, this upset me, etc., etc., etc. But that doesn't give you any sort of context against which to weigh the injury. And for those of you who are Marvel fans, you'll recognise the picture on the slide of Thor in Ragnarok saying, really, to Bruce Banner. And that's quite often what you get in response in respondents' witness statements and witness evidence. You just kind of shrug your shoulders and say, oh, seems a bit high. Now, one of the problems with CVP is when you're showing questioning Thor face, if we can call it that, to a witness and to the tribunal, in in-person hearings, they were the only people who saw that face. Now on CVP, everyone who attends the hearing and everyone who observes the hearing gets to see you pull that rather unflattering face when you're seeking to challenge the evidence of the claimants. Now, how do you challenge inherently subjective piece of evidence, i.e. the claimant saying, I was very upset by the treatment I received? Well, it seems to me you test the credibility of that evidence, the seriousness of the actions, and the causation. Now, as I say, we've got to remember, and that this is the point that unfortunately lazy advocates fall into, is they forget the fact that injury to feelings is not there to punish the respondent. It's there to compensate the claimant. So the goal is to look at the impact on the claimant. It's not to dismiss the injury. If you're fighting a remedies hearing, you've necessarily lost something. You can't go behind in the tribunal. You can't go behind their findings. So what you've got to do is, whilst not dismissing the injury, you've got to show evidence that justifies the award. And are there any other factors that reduce or explain that award? And the aim is to put forward a logical and clear counterpoint and a basis for the assessment. It's highly unlikely you're going to be saying there is no harm. And to touch on Amrit's point earlier about there needs to be some evidence, the threshold for a claimant to meet is relatively low. There's a recent case whereby the claimant, it may be the Eddie Stobart decision you referred to earlier, said she was shocked by the rejection of her grievance, and that was enough to clear the hurdle for the claimant to show injury to feeling. So it's going to be very unlikely that there's no evidence from some harm. The issue is, how do you reduce it? And I think there are 10 tips that we can work on and work our way through when you're trying to construct a credible counter schedule and a credible counter argument. Well, the first is to scrutinise the seriousness of what the claimant's saying. That is the touchstone of injury to feelings. That's what Vento talks about. What is the seriousness of the impact? So has the claimant overstated their injury? Are there inconsistencies as to how they presented at the time? And are there inconsistencies between their description and their behaviours? Look for boilerplate, vague and generic terms in claimant's witness statements. Often you say, oh, well, I was distressed, humiliated and upset. No specifics on that whatsoever. So look for those generalities. Put forward your own assessment, and the form of words might be something along the lines of, I know, the incident was limited, resolved quickly, and there was no complaint was raised for several weeks. Any injury would fall at the very bottom end of Vento of around £1,000 or £2,000. So put forward a positive explanation with your own assessment. And I think, well, when we work our way through, I'll try and formulate some examples of relatively, hopefully, coherent forms and words for each of the points. So that's the first of the 10 factors I think respondents should look at. The second is look at the mitigation. To Amrit's point earlier about what has the claimant done to recover? Has the employer taken any steps to remedy the harm? Have they offered an apology, support, counselling, moved to a different manager? And these are all relevant factors. And whilst they don't cancel the injury, they can certainly reduce the seriousness of that injury. If you want to look at, if I want to sound like one of those cheesy adverts for shows or films, if you only see one show this year, make it this one. If you only read one tribunal judgment, read the Wood, Hope and Salford City Council case. It's a first instance tribunal decision a few years ago, as a way of showing what not to do if you're a respondent. In that case, it was all about school teacher, and the head teacher got, by the sounds of things, a bit of a panning by the tribunal as to their conduct and their behaviour. They produced a witness statement for the for the remedies hearing, seeking to basically criticise the tribunal's judgment at every stage, and then didn't turn up to give evidence. And the tribunal really took against them. There's no apology. There was still challenging, and going to Amritpal's point a few moments ago, resulted in aggravated damages and a high injury to feelings award. So that's not what to do. How would you frame a submission? Looking for mitigation. Explain what the respondent did. The respondent took prompt steps to acknowledge and address the issue. Support was offered. Working arrangements were changed. Set it all out nice, clearly, page references in the bundle to support what you're saying. And again, this goes to show a lower award in the lower bracket of Vento would be relevant because it's not as serious as the claimant is saying. Therefore, the impact on the claimant is not as bad as they would have you to believe. The third way respondents can reduce compensation is to test causation. Obviously, the injury must flow directly from the discrimination, and feelings injured by unrelated conduct can't play any role. Look at the Coleman and Skyrail decision on that point. So to press the point, is the injury the result of an act found to be discriminatory? If it's something else, the grievance process or being placed on leave or whatever, or general dissatisfaction, that cannot influence the assessment. And so respondents should be aware and be alert to arguments being advanced that the dismissed parts of the claim form somehow the backgrounds to the remedies matter. They don't. And again, be alert to divisible and non-divisible injuries. I spoke a few moments ago about establishing a baseline in evidence. Challenge that. Is the image the claimant wants to portray of them being happy in their job and to use Amrit's words, that they were tied up into their role? Is that really it, or did they actually dislike their job? Is there a colleague who used to, I don't know, would say that the claimant used to go to the pub with them in the evenings, or would always used to complain at tea breaks? If so, then you're lowering that baseline, and the injury to those feelings is not likely to be quite as much. This involves, I think, if you're trying to formulate a form of words for your response or your counter schedule, it involves a bit of tact. I think you have to accept the claimant found aspects of the working environment difficult, but the acts found in discrimination, or the acts found to be discriminatory, are narrow. There's no clear evidence that this act on its own caused injury to the injury described. Therefore, the remedy must be confined to the injury caused directly by that act. You can go further. The alleged injury appears to flow from unrelated workplace conflict, a prior grievance that wasn't answered, or from the claimant's own dissatisfaction with work. These are issues that are not compensatable. So set out in clear terms what your position is. The fourth basis on which it can be challenged is to echo what Amrit said a few moments ago, is distinguish between an indignation and injury. Is the claimant trying to recover compensation for how appalling the conduct is or was, or is it how it made them feel? They're not always the same, and it's only the latter of those two which is recoverable. Look at the language that the claimant uses in their witness statement. I could not believe they treated me that way. It's unacceptable. That is moral outrage. That is not to do with how they felt. That is not recoverable. I say earlier, I was shocked by the way my grievance was dealt with. That is injury to feelings. That's saying how they felt, rather than showing moral outrage. How do you direct the tribunal in dealing with that? Grasp that nettle. Say the claimant clearly disagrees with how they were treated, but disagreements and disapproval are not the same thing as injury to feelings. The tribunal must base its award on subjective harms suffered, not its disapproval of the conduct of the respondent. Fifth point, probably closely related to the fourth, do not conflate the manner of the act with the injury. As shocking as an act may be, it may not result in significant injury. A mundane act might. So look to focus on the impact and not the outrage. Again, difficult argument or a sensitive argument to run, and certainly one that you want to explain to your respondent clients before they hear the words fall from your mouth at the tribunal. But say that the conduct was wrong, we accept that, but the tribunal's job is not to punish that. It is to compensate for the actual injury. The manner may have been clumsy or public, but there's no evidence that it's caused sustained emotional harm. Again, focus the tribunal's attention on the actual injury to those feelings as opposed to the act that brought it about. Again, just as the claimant will seek to produce contemporaneous evidence, the sixth point is the respondent should equally look at contemporaneous evidence. Was there any protest at the time? And whilst silence is unlikely to be fatal, it may start raising questions. That said, I think all respondents have to be alert to the fact that tribunals understand the power dynamics in employment relationships, but they still will expect a credible explanation. Again, what can respondents, how can respondents address that? Well, they can say that their submissions, no records of the claimant reporting any distress, remained at work, submitted a positive appraisal the next week, all objective evidence that is contemporaneous and hopefully goes to reduce or undermine any claim that this had a serious emotional impact on the claimant. If you want to go a bit further, you can or at least acknowledge the power imbalance. While we do not suggest that every distressed claimant raises complaints immediately, the absence of any explanation over a sustained period of time calls into question the extent of the injury that's now being claimed. Coming up to number 7, look at the acts that have been proven by or accepted by the tribunal and seek to limit them. The claimant may allege 10 acts and succeed on only 2. And as I said earlier, might try to roll those remaining or those unsuccessful cases into background or context. But the award must match what has been proven. And so I think respondents must be robust in their position on that, saying the tribunal rejected the majority of the claimant's allegations. And so, put it in stark terms, it would be wrong to compensate the claimant for being her feelings of being genuinely mistreated. Compensation can only follow from the acts that are found to be unlawful. Set that marker down for the tribunal, get them very aware that you know what the boundaries of their powers are. I think 8, acknowledge anything that was done right. Has there been an apology, quick action, support offered? If so, say so. While the act of, whilst the act of discrimination was regrettable, the respondent acknowledged it quickly, apologised, offered support. The claimant, and that kind of dovetails into the points we talked about earlier about the claimant remaining in post and declining further assistance. If you're able to say this is not a case of discriminatory culture or indifference, the employer responded seriously, sensitively, quickly. The tribunal is entitled to reflect that in a lower award because of the impact that would have had on a claimant. Obviously, point 9, spotting consistencies. Is there a disconnect rather between what the claimant said at the time and what they're saying in their witness statement? Social media is a litigator's goldmine. Often there's a lot of material on there that can be brought up to show that the claimant didn't actually go into their shell afterwards, if there's lots of photographs of them out partying every night over a period of time. Again, has to be done sensitively, particularly in light of the very low threshold necessary. So quite often you'll see a concession given there. So we don't suggest for one moment the claimant wasn't upset, but their conduct, going to work, apply for promotion, that sort of undermines the claim that this incident caused them serious and lasting injury to feelings in relation to how they were at work. Or if you can be more bold, the tribunal must assess the claimant's injury to feelings in light of their conduct. Someone experiencing a level of distress described as unlikely to joke about the incident or going out when they say they aren't. So really throw it back to the tribunal and highlight to them the inconsistencies that are there in the material. Touching on, I think, kind of drawing all those together and touching on something that Amrit mentioned a little while ago, is watch your own tone in evidence. Don't undermine all the good work in your presentation and the evidence by being overly aggressive in correspondence. Overly combative litigation, often backfires. I've yet to see one claim this year, probably goes back a couple of years now, that doesn't claim some sort of aggravated damages. What I say in relation to any sort of litigation correspondence is dance like no one is watching, but litigates like it will be read out in an employment tribunal. Be very careful. Obviously, you've got to be assertive, and you've got to be able to say you've represented your clients to the best of your ability. But bear in mind that overly aggressive correspondence doesn't work. And it's likely to antagonize the tribunal and certainly potentially raise issues of aggravated damages. What I do when I'm dealing with cases coming up to case management hearing, and I see a claim for aggravated damages, I do push back a little bit and say to the claimant's representative, what are the circumstances of aggravation? And so if they haven't already done a schedule of loss, I will request that be included in a schedule of loss. If they have done a schedule of loss, I'd expect the representative on the day to be able to say, we say the circumstances of aggravation are 1, 2, 3, 4, and 5. I think that's only fair to the respondents' representatives, because the tribunal are going to have to make findings of fact on that. And if that's not set out in an early, if it only comes to light in witness statements, there's going to be an inordinate amount of time, supplemental questions being asked at the tribunal when timetabling is already tight, and the tribunal may not want to spend an extra half hour per witness addressing aggravating circumstances, whereas you've got it in the schedule of loss, or if you've got it in the case management order, they know, or the respondents know early. And again, going back to my point about that hinterland between the the response being entered in the case management hearing, if the claimant's done a voluntary schedule of loss, setting out, these are the 6 reasons we say aggravated damages, shows the respondent early doors, along with a fully pleaded or fully particularised injury to feelings claim, that you're thinking about aggravated damages in a sensible way. Again, just puts a little bit more pressure on the respondent's representative to obviously have to discuss with their clients the economics and the likelihood of achieving that sort of award. So moving on then away from questioning foreface to common areas of confusion. Remedies hearings without findings of fact. This is a real problem, I think, that much like Polkey and contributory fault in the unfair dismissal hearing, I think there has to be, at the liability stage, some assessment of factual findings necessary to underpin any injury to feelings awards. Without it, how can you even begin to have any sort of meaningful remedies hearings when you don't know the framework within which you are going to be adjudicating or arguing? A second failure is the manifest failure that we've touched on, we've spoken throughout, schedules of loss. Schedules that simply say injury to feelings, £25,000, middle band vento, more than one act. Totally wrong. One of the cases that Amritpal referred to earlier recently sets out a very good 7-stage process for what a tribunal needs to go through in assessing injury to feelings and the steps they must go through. A schedule of loss or witness statements should do exactly the same as far as I'm concerned. And Gordon Exel, who does a brilliant blog on civil litigation, says in relation to counter schedules, a lazy counter schedule does actually more harm than good. So too often you see counter schedules that simply say nil, nothing. The claimant's not entitled to this award, rather than actually wrestling with why or setting a value or just a range of values and saying, we say this is a lower band Vento case because of X, Y, and Z, rather than simply nil, not entitled to anything. Other heads of loss, we've touched on this throughout. Aggravated damages, make sure there is the separation between injury to feelings and aggravated damages, although the tribunal would likely to make an award of X £1,000 injury to feelings, brackets including Y £1,000 for aggravated damages. Stigma loss, get your evidence in place on that, and also personal injury. That does require some degree of medical evidence if you are going to sustain any sort of claim there. Often overlooked, but really shouldn't be, is interest. The tribunal has an obligation to consider interest, even if the parties don't raise it, but that's not a reason to forget it. Again, a nice early schedule of loss saying injury to feelings, assessing an injury to feelings, giving an amount, and then saying interest at 8% per annum from the date of the act until date of assessment. If you were to put a pound, shillings and pence value on the daily rate of what you say that's worth, again, for claimants, that's got to be worth its weight in gold in saying to the respondents, look, every day you don't settle this case, this amount of money goes up. And the respondents are aware of that very, very early. And when you're looking at listings times going into 2027, those 2, 3, 4, 5, 6, whatever it is, pounds per day add up over 2.5 years. So those are my top 10 tips for employer representatives and areas of confusion. Let's presume that the confusion remains. And so Amritpal is going to now talk about what you can do when the tribunal or the other side get it wrong.
Thank you, Michael. The paragraph you referred to earlier is the case of Sadia Shakil versus Samsons Limited. We should have that in the handout. It's in some of the earlier pages, but I can give you the citation. 2024 EAT 192. What if the tribunal is not happy with, what if the claimant or the respondent are not happy with the award? Well, the option there is to consider appealing. It's important to remember, however, that the tribunal has a wide margin of error, and this has been accepted in a number of cases. An appellate court may only interfere with a tribunal's assessment of compensation if the tribunal has acted on a wrong principle of law, misapprehended the facts, or made a wholly erroneous estimate of the damage suffered. Again, that was from a case Michael mentioned earlier, Skyrail Oceanic versus Coleman, 1981. It was repeated again in Vento, and again, there the tribunal says in these circumstances, an appellate body is not entitled to interfere. So much more stronger with the assessment of the employment tribunal, simply because it would have awarded more or less than the tribunal has done. And again, it goes on to repeat wrong in principle, misapprehended the facts, or wholly erroneous. And more recently, in Land Registry, HM Land Registry versus McGlew, it refers to manifestly excessive or wrong in principle. An example of manifestly excessive is the case of Eddie Stobart, which we've referenced in our handout. The point here is that it is difficult for the tribunal it's not an exact science. That's the first most important thing. And if it's not an exact science and the tribunal will make a global award, there is going to be a margin of error there. And so it's very important before embarking on an appeal to consider how the tribunal has reached its decision. So often, for example, an error in legal approach might be, a good case for that is Metropolitan Police versus Shaw, it's 2012 case, ICR 464. And in this situation, for example, treating an award of injury to feelings and an award for aggravated damages as two entirely distinct concepts of damage. So, for example, in that particular case, the tribunal made an award for aggravated damages purely on how they considered the behaviour of the employer and considered it high-handed or oppressive behaviour. The key thing, it was then Mr. Justice Underhill explained that it's aggravated damages about the aggravating features of the act, which then to increase the injury to feelings. It's not a separate award. Then there's analysis of evidence. Again, the Metropolitan Police is a good example of that. If there's errors in analysing the evidence, for example, considering there was no evidence of an injury when there was, or including aggravating features that the claimant wasn't aware of at the time. I mean, if the claimant's not aware of certain features that could be aggravating, it's unlikely that those then would have aggravated the injury's feelings, as it were. Then there's misapplication of relevant guidance, obviously with things like personal injury. There's the Judicial College guidelines. There may be misapplication of the vento bans if they're not the correct ones used from the time the claims presented. If there's double counting across heads. A point Michael touched on was the divisibility of the injury. It is only those where factual findings have been made with respect to an unlawful act. So those acts that are successful and there has been unlawful discrimination are the ones that from which injury to feelings will flow. And so if there isn't that rational explanation or a basis of how the award's been divided, that is then potentially open to appeal by the respondent. Equally, there may be reasoning within the decision, for example, tending to suggest is a punitive approach. So, for example, in the Metropolitan Police case, the tribunal had mentioned that the employer should not have behaved this way, and the AAT commented that it tended to suggest that the mindset was awarding damages that were a form of punishment. But it's important to remember that there is still a wide margin of error with injury to feelings, and a summary of the sorts of challenges that could be made are also identified by His Honour Judge Taylor at paragraph 24 of Sadia Shakil versus Sampsons Limited. So that case has some assistance there as well. It sets out very clearly the process the tribunal is going to engage with, and then it sets out the sorts of things that can go wrong as well. And a good example of a manifestly excessive case is a recent one of Eddie Stobart. So that concludes our talk. We do have some time, or very. Do we have time? Or,
yeah, I think we've got two questions in in our questions box.
The first one, it's a good question actually. I mean, should evidence of injury to feelings be in witness evidence for liability or separate evidence on remedy? I mean, I've seen this been done in both ways actually. What are your thoughts on that?
If you've got the combined hearing for liability and remedy, I think there should just be one witness statement dealing with it both. If it's a separate remedies hearing for whatever reason, I still think there needs to be material in the witness statement that is relevant to the issues or relevant to the factors that you want the tribunals to take into account as and when you get to remedy. It goes to the point that the tribunal are going to need to make factual findings as to various matters that will be relevant to remedy, the duration of the discrimination, any impact it had if that resulted in time off work for ill health, that sort of thing. I think that has to be dealt with because it forms part of the factual matrix that the latter remedy hearing will be addressing. The second question is, if the claimant is a litigant in person has not adequately detailed injuries things in a witness statement, to what extent should the judge ask additional questions to deduce this? Would this also apply if the claimant was represented? Well, dealing with the last of those first, if the claimant is represented, I think it's difficult for a judge to descend into the arena and start doing the job for the claimant or the representative. Yeah. So I would be very, very unhappy if a judge did that for a case I was representing. With regard to litigants in person, it's obviously the judge has to give the claimant an opportunity to put their case and have a fair hearing. And so I suspect what will happen is a judge would ask an open question to a claimant, and if they didn't get an answer that they were shocked or unhappy, or anything that goes to injury to feelings, probably ask again in a different way, possibly then ask a third time. But if after 3 times or 4 times the judge doesn't get an answer that supports any possibility of a finding, I think the judge is likely to move on, having given the claimant ample opportunity to explain what their case is and what their complaint is. So I do think a tribunal would be more, I use the word guardedly, but inquisitorial when it's a litigant in person than when it's a represented party.
So thank you so much for attending from both me and Michael. If there's any unanswered questions, we will follow those up by email. A reminder, if you are watching the recording and have any questions, you can email them through to events@42br.com. The recording of the webinar will be available on the website and YouTube channel shortly, and we'll be grateful for feedback. The final session in this series will be Time Moves in One Direction, Memory in Another, the role of memory in the Employment Tribunal. And that final session will be hosted by our Jason Breyer and Safia Theru on Tuesday, the 8th of July. Please do sign up for that one as well. And that's it. That's Good evening from Michael and myself.
Thank you.
Thank you.